Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Taman.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your host, Ben Siders. That's me, and the other guy is Kirk Damon.
That's Kirk, as in the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN. You can find the podcast at LGG Pod. And newsflash, we are now on YouTube.
We're on YouTube, yes.
We have leveraged the diligence and hard work of a thankless intern to get all of our stuff put on YouTube. There's no fancy graphics or anything there, but the content is at least all of there. So we're working on putting together playlists that will cover specific topics. I want to do one that's got like all of our role-playing game episodes, all of our Star Wars reviews. So if you just want to go through and just murder your brain with all of our analysis of Star Wars content, we'll have it all in one place. We haven't done that yet, but that's coming. So we are on YouTube. I think it's youtube.com/@LGGpod or LGG Podcast.
You know better than I do.
I forget which one. Check them both. One of them is a different podcast that starts with LGG. So it's there. I'll find out and we'll fix that. But anyway, so that is being done. Today's episode, we are going to talk about the recent decisions in the Anthropic and Meta cases. If you don't follow AI all that closely, Anthropic and the Llama is the one for Meta, but these are both large language models. Anthropic's is called Claude, Meta's is called, like I said, Llama. They are trained on huge sets of data, and they are chatbots. You ask them questions, they produce answers. And this was, I would say, Kirk, this was the form of generative AI that kind of introduced the world to this technology a couple years ago.
Yeah, I think this is when people are thinking about AI technology today, this is what they're thinking about. They're thinking about these essentially chatbots. I mean, that's the way to think about them. But the idea is you're going to ask questions, it's going to respond to you, it's going to answer those questions, and it's going to give you data based upon what you ask for. And that data is based upon what it has learned. And I think it's important, with this, particularly something like this, to be using terms. That term learned, I think, is a very important term. You have to teach an AI what to do in conjunction.
But teach kind of belongs in quotes. It's not quite teaching. We'll get into that over the course of the podcast. But we use this nomenclature. We kind of anthropomorphize the AI, perhaps at our hazard.
I think some people definitely think these things are alive. I mean, the people who even today think they are already. They think
wrong.
They will be soon. But I'm not sure that they will be. There's also people who look at them and say they're not. I think we're going to both fall a little bit more in the not category.
For LLMs, I'd say definitely not. This is a whole another episode we can do. The robotics stuff is more interesting, but we've kind of capped out what LLMs can be trained on as it is. So I think we're reaching the peak of that. Okay, so I don't think we're likely to see massive explosive gains like we did when the stuff first came out. But who knows? We'll see.
Yeah, I think the biggest issue you've got with it is that there's no more data to really train on. Yeah. They've kind of used all the data that's out there. We've used the world of data that exists. It's going to have to start feeding data to itself, and we already determined that's not working very well.
Yeah, the synthetic decay problem.
Yeah, I mean, we may very well see new algorithms. I mean, my understanding is that they are working on new algorithms. The algorithms are getting better, but at the same time, to me, that's more incremental gains. We're not going to see something totally change.
I think the important part to bear in mind with all that is that we're ultimately dealing with text-based models. We're being trained on textual data, which, there's a lot of it, although, as you said, they've pretty much trained on what there is to find. So unless we find new troves of human-generated data, we've pretty much got it all. And we can't just use the new stuff on the internet because a lot of it is AI-generated, and we know that it doesn't do very well with that.
Yep. Now, there's imagery as well, but I think we particularly want to talk about the idea of these being the text-based bots.
Yeah. Well, these lawsuits are about authors and text-based stuff. So two cases, Anthropic and Meta. Let's go through real quick what the copyright issues are. I mean, obviously, books and written materials are generally copyrightable. The stuff they're scraping is generally copyrightable. What they do to train the AI is acquire copies of the source materials, whether by purchase or lending or stealing, but they get a copy or finding online, which is sometimes stealing maybe and sometimes not. And then the works are digitized if necessary and fed to some software that does statistical analysis of the structure of the text or the data underlying the text. It looks for statistical patterns and it produces a model of what that looks like.
Yeah, and I think that what we're really talking about here, a few things to keep in mind, we're talking about primarily, literature data. We're talking about, spoken word, but
literary works
that are really written word. And we're talking about works that have been digitized. So you've got to digitize in order to have the computer use it, to have the AI use it. So we're talking about digital literary works. Now, obviously, you can have audio works, but in some sense, an audio work is going to be similar to a digital literary work. The reason I just want to go into this is because we're going to sort of, in some sense, dramatically simplify what we're talking about here.
This is all very simplified.
You know, we can't talk about every kind of data. We got to just kind of talk about one very small kind of data. And the kind of thing they're talking about here is what we would call written word.
Yeah. So the copyright implications are relatively straightforward. This is about training the AI. These cases are not at this point about the outputs. They play into the analysis, but here the important takeaway is that these are our first fair use decisions about whether training an AI using the stuff you find out there online or otherwise get a hold of is okay or not.
So basically we have the idea that these AIs have at some point in time absorbed all literary work which is available on the internet. That, and I think it's also worthwhile to just sort of point out, we're going to assume it's everything.
Yeah.
That, basically they've taken in everything. They've probably taken in multiple copies of certain things. We don't know how they're training these specific data sets. That's going to be proprietary. But for the purposes of this analysis, we can basically assume if it's on the internet, it has probably been absorbed by an AI engine at this point in time.
Yeah, and the issues raised are whether doing that infringes the right of the right to reproduce the work in copies and the right to prepare derivative works. The training itself doesn't really implicate any other copyright rights. The other rights are all publicly facing things like public display, sale, distribution, not implicated here.
And that's all based upon output. A distinction I have to make when I'm talking about AI issues is you have sort of 3 points in time having to do with what an AI is handling data. You have the idea of it taking in the data, it internally processing the data, and it outputting its own data. We're not talking about it outputting its own data in any way, shape, or form in these cases yet. We're talking about how it takes in the data and potentially a little bit about how it's processing and handling the data internally. But even that, in many respects, we don't know. That's kind of a black box. We don't. And
we're
really
not going to know.
The data.
It probably doesn't matter for purposes of, at least for these rulings, it definitely doesn't matter.
So we're really talking about how it's taking in data. So the idea being, can it take in this data and store it, knowing that it's storing it in not in the form that it's taking it in. There is processing ongoing, and what it is storing in its memory is not what it takes in. It does not keep a literal copy of everything that it absorbs.
So the first case that came out about 2 weeks ago was called Bartz v. Anthropic. Authors had sued Anthropic for using their books, some of which were claimed to have been pirated, some were purchased and then digitized to train Claude. Kirk uses Claude, so...
Yeah, I use Claude.
The judge, his name is Judge Alsup in the Northern District of California, analyzed this from the point of view of the 4 fair use factors, and I guess we'll run through them as we look at the case. Judge Alsup said the first factor is the purpose and character of the use.
Let's just do a little bit before we get into it and talk about fair use.
Yeah.
We tell you, so basically fair use is in a defense to copyright infringement. It says you did still commit copyright infringement under the act, but that's an okay thing to have done because we recognize that some forms of copyright infringement are necessary for sort of the world to work, and we want to promote them as well. The way we basically make that decision is we've come up with a 4-factor test that says we look at these 4 factors based on what specifically was done in this particular case and determine, based upon those 4 factors, do we think it's fair use and it's okay? So again, it's infringement, but we think it's okay. Or do we look at it and say, no, it's infringement and it's not okay? So the real thing we're looking at with this is looking at this as being a balance of saying, we have committed copyright infringement, unquestionably, in order to get into the fair use analysis, but is it okay? And so that's what we're looking at is it okay? And we do that based upon a balancing decision based upon 4 factors. So let's get into the 4 factors.
Well, I want to do one little point of doctrinal precision. The text of the Copyright Act actually says that the fair use of a copyrighted work is not infringement.
It's not infringement.
But as a matter of allocating the burden, we treat fair use as an affirmative defense, which again, doctrinally means I admit that I did it, but I shouldn't be held responsible.
Yeah.
So it's a minor point, but you sometimes see certain public interest groups like the EFF really get upset and uptight if you don't kind of make that point. So this is all this to say, we know fair use is not really an infringement, but that's a shorthand for explaining how it's done procedurally. Okay, so the factors: purpose and character of the use. The Copyright Act says, is it for commercial purposes or for educational nonprofit purposes like news? Which, as we said many times, is a false dichotomy.
Yeah, because in many respects, what we get into in conjunction with these things is it's always a little bit of both. Everything has some commercial aspects. I can have a completely non-commercial use, but it involves some commercial down the road. That can be found a commercial use. You could have something which you'd say, oh, it's clearly commercial, but then you look at it and say, no, it's not because no money actually changed it. Well, you don't get into it. Yeah. What a lot of times you get get into in conjunction with this is transformative.
Which itself has kind of two pieces.
Yep.
Is the new work a transformative work, meaning it changed the original significantly, and or is the new work a transformative use of the original work, which may have been transformed, or may be the original work verbatim, but used in a new and different way. That's the classic Andy Warhol situation.
And in this case, remember, we're not talking about the output. So we're really talking about the second one of these things because we're not looking at what the output looks like compared to the input.
We're looking at the model that's being created by analyzing the data and doing the copying.
So again, the case in this, the output in some sense is the black box AI program that exists, which we don't really know what it is.
A lot of data.
Yeah.
Okay, the second factor is the nature of the work. Is it the type of work that gets strong copyright protection, like highly creative works, or is it a more utilitarian work like software,
phone book,
things that get thin copyright? This factor almost never plays a role, except in Google v. Oracle, where it was perhaps decisive. And here it favors the authors, obviously, so that one doesn't really. Yeah,
we're going to mention it, but it's not really important.
The third factor is the amount and substantiality of the original work that was used in the new work or use. This one's interesting because it often falls out of it often favors whatever the outcome is, but it also often effectively falls out of the analysis because you can usually frame this in a way to reach either conclusion.
Yeah, the best example of this is what is the work and what we're talking about, because every work involves multiple things. And so you kind of bump into that idea of saying, well, is the work the entire phono record or the entire, recording that the artist made, or is it the first note of the first song?
Yeah.
Because I copied 100% of the first note of the first song, and that means I copied, 1/1000th of the entire album.
Yeah, if I infringe the epilogue to Harry Potter, okay, it's 100% of the epilogue, but it's like 1% of the book.
Exactly. And so the problem you bump into with this is, in some sense, what you see judges do is they can define the work based upon whether or not they want it to be copied by how percentage. And we saw that a little bit in the Google case.
Google Oracle was like that. Was 100% of the API or virtually none of the actual language?
Yeah, and they found it to be, if I remember, virtually none of the actual language. Yeah. And so, that's going to be, so with these kind of cases, now I do think this one turned out a little weird in this case.
This one is weird. So Judge Alsop said this factor favors fair use because although Anthropic used the entire work, it was because they had to. They needed a lot of data, and so you need to use the entire work. So this goes to sort of the way that this factor plays out in practice is not so much did you use all of it or a little of it, but did you use only so much as you needed to use to make the use that you want to make of it.
Yep.
And here the judge is like, well, you have to use all of it because you need tons of data.
Well, and the thing that I think is interesting about this, and we were debating this a little bit before we started recording here, to me, one of the things that Judge Alsop seems like he's saying here is because you need so much data, you have to copy the entire library. So since you copied the entire library, one book, even though you copied it in its entirety, is not that much of the library. But that's not really the analysis. The analysis is, but is it a lot of the one book? It's not the library.
The entire library is not a plaintiff here.
Yeah, it's the one book. And so it does kind of have a slightly weird feeling because it feels like he's trying to say it's a small percentage because you need lots of data, even though it's 100%. And it doesn't make a lot of sense. But I think the real key behind it, I think, is that analysis of you needing lots of data. Him looking at it and saying, there's no way to do this. The necessary part is all of it plus a whole lot more.
Yeah.
So therefore, obviously, it's all of it because you have to use all of it plus a whole lot more.
Well, when we get to the meta case, we think there's a better framework for looking at this. And the fourth factor, which is by far the most important and usually decisive, is the effect on the market for the original caused by the new work. And here, Judge Alsop said that although AI can generate competing works, copyright doesn't exist to shield you from competition. It exists to promote new authorship, and that's what's happening. So what's the problem? I
think this is where we get into a little bit. And I was going to mention, I don't think we really kind of gave an output for the purpose and character question. But I think one of the things that we've got with this and the market effect and the way we're coming to it is I'm kind of looking at it and saying, we're not looking at the output again here. We're looking at the mush which is inside the AI engine. That is transformative. There's no question that's different from what the book is. The book does not exist inside that mush. And probably there's no recognition of it at all. It's just part of a statistical
Some of the plaintiffs
engine.
have alleged that you can get it back out.
Now, you can't get it back out, and that's an intriguing question. But again, we're talking output.
Yeah. We should say with like the Midjourney case we talked about a couple weeks ago is different. You can say, give me Darth Vader, and it can give you Darth Vader.
Yep.
So that's a different situation.
So it's a slightly different situation, and I think a very important sort of distinction. But in these, you're kind of looking at it and saying, but if we don't have Darth Vader stored anywhere in it, we don't have an individual scene of the movie stored anywhere in it, we've just got statistical analysis about whatever it is. That's not the work in the end. And I think that's what they're kind of trying to look at there's no real competition there.
Yeah.
It's now in the end, if it spits out, here is, Gone with the Wind word for word. Well, that may be an infringement. That's your problem, but that's not what we're talking about here.
Kirk and I both, when we saw this, we thought, what Judge Alsop is saying is definitely true. But I don't know if it misses the mark or maybe it's a simplification, but this probably has to be looked at on a work-by-work basis, whether any given output has enough copying of protected expression to constitute a derivative work or copyright infringement. I don't think you can have a categorical rule here that all the outputs either always are or never are. And when we did our comments to the Copyright Office when they were asking for people's thoughts on this, that's basically what we said. But I think there's maybe a different issue here. We often see people analogize what AIs do. The argument is made, isn't it just learning the way people do? Conceptually, the situation is similar to how a human author would work. You're going to read a bunch of books, learn about language and syntax and narrative structure, and then you're going to write your own new original stuff, and it is informed on some level by what you learned. That's what the AI is doing. How is that different? And the obvious answer is, but it takes me a decade to read enough books to learn how to write a good novel, and then it takes me at least a couple of months to turn out a 100,000-word manuscript, whereas the AI can, be trained and produce, 1,000 books in 3 hours. So, but that doesn't get to whether it's an infringement or a fair use so much as how quickly and on what scale you can produce the competing works. Does that and should that matter to the fair use argument? That, I think, is less clear, but I'm leaning towards it's still relevant.
Yeah, we talked about the idea of this being an energy barrier issue.
Yeah.
And the idea of it looking at it and saying, it feels like copyright kind of looked at it and said, yes, training a human has an energy barrier. It takes a long time. That energy barrier is gone. Yes, it still takes an enormous amount of data. It still takes some time, so that you can train an AI overnight. Well, you can if you use small amounts of data, but the large ones that you're going to be taking in and questioning in these stages. But the real question with it is does that change it somehow? The fact that it takes you a year to do it versus the AI taking 10 minutes, does that matter?
Yeah.
And the answer is it probably shouldn't, but it kind of feels like it does.
It feels like it's relevant, right? And we've seen this in the past where so technology tends to disrupt copyright, oddly more so than patent.
Yeah.
But technology tends to disrupt copyright, and historical solutions to these problems have at least implicitly relied to some degree on the energy cost of infringement. And we were talking before about how we saw this with DART, the digital audio recording tapes, and with the private copying levy on data CDs. We've talked about that in the podcast before, but we'll hit it really quickly. Back in the day, when you went to Best Buy to buy a CD, there was one package of CDs that said data and one package of CDs for music. What was the technological difference between those two products?
Zero.
There's none. It's the exact same product with different packaging, and most importantly, a different price tag. This music CDs were more. Why is that? Well, it includes a levy, the private copying levy. That extra money goes to, I don't know, it goes to ASCAP or BMI or somebody who knows how to distribute royalties to the music industry. That was meant to compensate the industry for all the infringement you're going to do, you rascal.
Yeah.
And that was built into the Copyright Act. And so why would you buy that then? Why wouldn't you just buy the data CD and infringe on that instead?
Because then it's an infringement. Whereas if you put it on the audio
That's
CD,
right.
it's not.
If you use the audio CDs and pay the copying levy, then you are statutorily immunized from copyright infringement claims, just like the ISPs are with the DMCA. So the idea was a trade-off. You get to copy scot-free, but you get not quite scot-free for the extra $2.50 or whatever it is. So that was the deal. So did that work? Yeah, for the most part. I mean, not everybody bought the music CDs.
A lot of people didn't, but I think some of us definitely did.
But at least it had enough of a political and economic consensus that it was good enough, in theory, to work. And there's a practical limit to how much infringement you're going to do. I'm not going to copy my entire library of iTunes songs onto a CD for you. That will take me forever. Buy your own damn music, Kirk. Like that's how people are going to look at it. Napster screwed that up. That barrier was gone. The social norm of being annoyed at your freeloading friends for copying all your music and never sharing theirs was gone. The energy cost to doing it was gone. The practical cost of having to buy the CDs and have it tie up your computer was gone. With Napster, you just turned it on and left and went to work, and it infringed millions of copies
and
while
actually,
you were gone.
it's sort of what we bumped into. There's a whole lot of discussion around, the legal industry at the time, which was, hey, the problem with the record industry is that they sell physical vinyl.
They sell stuff.
Yeah, they sell stuff. They don't sell music. And what people want is the music. And that's what Napster disrupted, is they allowed you to have the music without the physicality. And there had always been an energy barrier, which was you needed the ability to produce the physical stuff, which took huge machines. When we're talking about records, enormous amounts of technology. And so only record companies could do it. What we got to with Napster is the ability that nobody needed anything. Because the music existed, for lack of a better term, ephemerally. I mean, that means something particularly in copyright, but the music wasn't associated with anything solid.
Yeah, it was media or format independent. Like, at a digital format, it was media independent. You could put it on a CD, a data CD, or a music CD. You could put it on a hard drive. You could transfer it easily.
You could put it on a magnetic tape.
Yeah, it became much more mobile and flexible all of a sudden. So that was weird, and that was scary.
And you could store it, you could store it magnetically. You could store it as a series of bumps. You could store it as light. You can store it as essentially anything that could essentially create a wave.
So we have the same situation here now, although conceptually maybe it's not that much different than how human authors learn and produce things. The scale and speed, I think, is economically and commercially different. And it may be that the Copyright Act doesn't provide an answer to that, just like it didn't before, and we had to enact new laws to deal with it. So I think that's an important distinction, that although it does work in a sense the same way as a human does, the scale does make it a factually different circumstance. But there's another issue that makes it different. What the computer is doing is not really what the human being is doing. The human being is learning from the expression. The computer is learning from the data representing the expression.
Yep, and we're going to get into this. I know we're going to get into this a lot more later, but let's get into things. Remember that copyright, and we've talked about this in prior episodes, copyright protects the expression. It's all about expression. And part of one of the things we're going to get into here is what the heck is expression?
Yeah.
Because there's also data here. And that data is not necessarily expression, or is it? And so what we get into, the problem with it is that when we start looking at the way a human copies something, if I listen to a piece of music and I recreate the same music on my guitar, I have heard the expression because it has to have been played for me to recreate the expression. Or I have to have read the instruction and implemented it, thinking about the idea of it being, something that in order to create the end product. I can't go from somebody just saying, here's notes, to generating the piece of work, because I don't think that way. But in some sense, that is how an AI thinks. It says, I have a whole lot of collections of notes and I want to put them together in a way which is pleasing. I can put them together in this way. We don't entirely know how it comes up with that, but obviously it's some form of statistical analysis. So we bump into the idea that a human expression is based upon a human expression. So we learn from expression. It's hard to say humans don't learn from expression. But
we definitely don't learn from the data, right?
Yeah.
Like when you want to understand how a digital image works, do you go look at the bits and bytes in the JPEG? No, I need a piece of software to render it for me.
Well, an example of the way I kind of think about this is if somebody was to hand me a book that's in Braille, I can run my hand over it, but I'm going to get nothing about the expression. Yeah. But I obviously can analyze how the dots appear on the Braille passageway, and from that I could generate what a word might be. From it, I could potentially figure out this is the... It's almost cryptography.
It is. I was thinking the same thing.
We're getting into sort of the human being the way you crack codes is kind of the way an AI works, versus the way a human does it is using the expression and comparing the expression. We also know that you can't hack cryptography without some understanding of expression. Mm-hmm. There's some
and statistics.
Yeah, and statistics. So there's some interesting stuff here.
So we're going to hit the second case, and we'll circle back to that point because we think it's probably one of the more fascinating parts of this whole AI discussion.
Yep.
So in the end, where did the judge come out? He granted partial summary judgment for Anthropic on fair use in training the AI.
Let's talk a little bit about the doctrinal sort of position of this. Summary judgment. I think we've mentioned summary judgment on this show before. Legally, summary judgment means that one side doesn't obviously win.
Yeah, summary judgment means a jury doesn't need to decide this. All the facts that matter, the two parties agree on. Well, if the parties agree on the facts, that's all the jury's here to do, is decide the facts that are disputed. If there are no disputed facts, the judge can decide the law. That's what the judge knows how to do.
Yep.
So that's what the judge did here. Granted partial summary judgment, meaning that there was many things that Anthropic wanted summary judgment on, and the judge said, some of them, you're right, there's no factual dispute, I can figure this out without a jury getting involved. Others, no. So summary judgment was granted on fair use as a matter of law on training. Highly transformative, no market substitute, used only as much as you had to, which is all of it. And yeah, nature of the work doesn't help any, but it never helps. So that was simple enough. But summary judgment was denied in part for how they got a hold of the works in the first place. There were two ways Anthropic got these works. They were accused of buying books, several million books, digitizing them, and then using the digital copies. And they were also accused of just plain pirating stuff that they found online.
Of using pirated sites, I think it was even more of it. So they're basically using sites which themselves had done an illegal pirating of the work.
Yeah.
But they were then, Anthropic was then using that site, recognizing that they're not pirating it from the pirate site. It's been pirated beforehand. Yeah. So in some sense, you stole the treasure chest the pirate buried, but that doesn't mean it's not still stolen gold.
Still stolen gold. And I think, so the takeaway there is that, setting the training aside, as I read the ruling, he would have found that there's no fair use on the piracy, irrespective of what they did with those materials. Whether they trained an AI or not, that was going to be not a fair use as a matter of law. It goes to the jury. They could still decide that it is. Mm-hmm. I doubt they will, but that's up to them. And then likewise, on the training side, doesn't really matter how they got a hold of it. That's a separate question. The training is a fair use, irrespective of how you got the materials, which I think makes sense because if you acquired the materials and did everything lawfully, then why do you need fair use at all? It's not an infringement in the first place.
Yes. I think the real key thing behind this is and again, I'm going to harp on it a little bit, we're only getting to the mush at the AI. We have no output at this stage. This is just pure training. And so when you look at it and say, I take a novel and I turn it into the code of an AI and, it's big, huge, massive database, I don't think you can really say they're there. Now, again, this is where we get into the Disney case and the Disney Midjourney case, where it looks like some of it may be stored. I think in these cases, and particularly for the literary works, the odds of it storing the actual text of any of these literary works appears to be no, it doesn't. And if it does, we can't really figure it out anyway.
Yeah.
And so I think the answer to it is no, it doesn't really have a copy of the book in its memory. It has mush based upon...
Not a literal copy. Yeah. It may have a partially... I mean, the allegation is that you can possibly get the work back out, but I don't think that's happened very often. I'm not an expert on that area, but my hunch is just based on how LLMs work. It's possible that when we see what looks like a near verbatim copy, it's just the stochastic generation happening to get close sometimes.
Well, but I think sometimes also you can basically say that, do this from, write the first paragraph of this book. It can potentially do it because of the fact that it can recreate it, but it's not that it stored it. It just, it knows how to recreate it. Now we're going to get into the second question about that a little bit here in a minute as well. But the key to me is really the fact that it's not like we just took a book and digitized it and stored the digitization. We processed the digitization.
And we stored what we processed.
And the underlying stuff is gone. Like it doesn't exist anymore. And that's a very, very important distinction because it's been processed. And I think we kind of recognize that. In the same way, we can kind of look at it and say, if I take something and I process it through my human brain, I haven't stored in my brain a copy of what it is. I have stored it. I have processed it in order to store it. Even though I remember it differently. I think any brain scientist will tell you don't recreate stuff exactly as well as you think you remember it. But you have what you have from it.
Let's talk about the second case, Kadri v. Meta. The ruling came out a few days after the Bart's decision. Same basic fact pattern. The authors had sued Meta for allegedly using pirated books to train Llama. I've never used Llama. Have you?
I've never used Llama, actually.
Actually, I hadn't even heard of it until this case.
I knew of it, but again, my son uses Meta for quite a bit, so that's the only reason I knew it.
So the judge basically came up with the same analysis. Purpose and character of the use, highly transformative. Nature of the use, of course, favors the authors. On the amount, similar, but I think slightly more understandable framing, favors Meta because it's reasonable to use the entire works for the transformative purpose. Yep. I think that's a sharper way to say it.
I think this judge did a better job of saying the same thing in conjunction with it. Really was is saying you have to use 100% of the work because you have to use 100% of the work.
Yeah.
And in order to truly transform 100% of the work, you have to use 100% of the work.
And then the market effect. This is where it gets interesting. He said the plaintiffs failed to create a record establishing the harm, but in what we call dicta, which is comments that are not necessary to the ruling but are nevertheless instructive, he said, future plaintiffs are likely to prevail on this point, which could prove dispositive if they can establish that harm. Which just everybody kind of obsessed with that phrasing, but it's just kind of a truism. Everybody knows this factor 90% of the time plus. If you win on this, you win on fair use. So if you are the plaintiff, then you've got to establish a record showing how you've been harmed by the market effect of the use. Here's the question, though. What's the market effect just of the training, and is it separable from the market effect of the outputs?
Well, and I think this is where we get, in some sense, this is the difference between this and, again, I was talking about the Midjourney case. I think this judge is kind of looking at this and saying, look, if it's got the frame of the movie stored, it's got the frame of the movie stored.
Yeah.
So you've copied it. That's the way it is. Now, it doesn't look like you did that because in this case, they didn't prove it. But that's not to say somebody couldn't in the future.
Yeah.
And I think that was really the key here is him looking at it and saying, we have the mush which is in its brain, or inside the AI. Having the mush inside the AI is not the same thing. But if you can prove the mush has a copy, the mush has a copy.
Yeah. And you can prove that by looking at the outputs and seeing that it's there. And certainly the use of the outputs could still infringe, although that may be uses by the end users who are much less interesting to sue than the actual AI platform.
So I really feel like, to me, I think they both had essentially, the same decision for the same reasons. But I think that
framed slightly differently.
And I do think the Meta case frames it much better. I think it's a more clear legal analysis, and it seems to fit with the technology a little bit better too, in my mind.
Let's talk about that. Kirk and I both thought that this really raises kind of a deeper philosophical question or tension in copyright that I don't know that courts have directly confronted, although they've kind of put together a gloss to deal with it. And that is when it comes to digital expression or digital representations of copyrighted works, what does the copyright cover? Okay, we know copyright protects original creative expression. It does not protect ideas. It does not protect facts, and it does not protect data. You can get a copyright in a data collection, but that has to have sufficient creativity and originality.
Yep, and it's to the collection, not the underlying data,
not the individual pieces.
We talked about things like copywriting the phone book. You can prevent somebody from photocopying a page of the phone book because that's the expression of the particular data.
Yeah.
But I can't stop somebody from placing everybody's address and phone number in alphabetical order because that's the data.
So here's the thought exercise. Suppose I come up with a document that is a listing of two-dimensional coordinates in a Cartesian system, XY coordinates, and then a value at each one of those coordinates. So I'm going to have x is 0, y is 0, and the value is 0. And then x is 0, y is 1, and the value is 243. Okay. What am I doing here? Well, I put together a couple million of these, and I now have the pixel coordinates and light intensities under the RGB gun in the monitor to display an image.
Yep.
So if I have just this list of coordinates and values, is that copyrighted?
Yeah, and it's really interesting. So one of the things I'll actually play around with this because when my final project, when I took my original computer science class at college, I did a system where what I programmed it to do was to take in any Word document, and I programmed it to take any letter of any ASCII character that appeared in the Word document, and then assign to the ASCII character based on what it was a duration and a wavelength. That's exactly what I did. I made music out of, a term paper is what I actually did. I also got recursive and actually ran its own code through it to determine what it was. But it made amusing bips and beeps as, a piece of music. But that was the point. What was I doing? I was generating a sound work from a literary work by doing literally this. It was a function that converted the two things between each other. So yeah, it's very interesting when we get into data, but it's what is the data versus what is the expression.
Yeah, so in a sense, so if I do this, and I give you this big list of things, and if you follow the instructions, you get, what were we talking about before, a Georgia O'Keeffe painting, something that's still under copyright, okay? Or a Dolly, I don't know, but a Darth Vader, let's say, okay? It's a still,
like the Georgia O'Keeffe.
It's a still frame from Andor. Whatever it is, it's copyrighted. If I just write this up, have I infringed a copyright? Have I made a reproduction in copies of that work? And I think you and I both intuitively, when we came up with the thought exercise, says it feels like no, that probably shouldn't be. But what's the difference between that and a JPEG? The JPEG is just an encoded set of instructions to the computer on where to put the pixels.
Yeah, and the issue with it is, though, is that the key thing about it, I think, when you bump into it, is your computer is executing that JPEG. But we can't say it's the execution makes it
right, because the courts treat the data as the fixation of the work, and that copying the data is still copying the work.
Yeah. And that's the philosophical question here. What we've really fundamentally got into is it's the tree falls in the forest, it generates a pressure wave, but is the pressure wave a sound if nobody hears it?
No, it's definitely a pressure wave.
It's a pressure wave, no question. We know it's a pressure wave, but is it a sound? And what we're getting into is we're saying if it's a sound, it's copyrightable, and if it's not a sound, it's not. Well, we know it's a pressure wave.
It doesn't really answer the question.
It doesn't really answer the question. And so, and that's what we're really seeing the problem here is we're looking at saying if we say it's just the data, there is no expression of the data, can we say it's copyrightable? And the problem we bump into is we've never had to separate the data from the expression. We say it is like, okay, this is the coordinates of what the thing's there. Yes, well, when I give it to an RGB gun, it will produce it on a monitor correctly. There's the expression. So therefore, it obviously is the data of the expression because the output expression is the same. When we're now talking about it being in the AI engine, the problem with it is it doesn't necessarily produce the same image when we tell it to do that.
Yeah, and also, I mean, the Copyright Act is very clear that data per se is not protected. So this was sort of a threshold question I had. Are there two copyrights in the JPEG? One in the image it represents, and a second one in the data. And we think the answer is no, the data does not get a separate copyright. But then we go back to the idea that the AI is doing what the human is doing. No, it's not. Yeah. As the human being, I'm not looking at the data and analyzing which ones and zeros are next to each other in the JPEG data. I'm looking at the light of the image that I perceive and how it looks. That's how I'm learning how to paint. The computer's not. It doesn't understand any of that. It only understands the ones and zeros. It has no comprehension of the resulting image.
And that's kind of the thing I think we're looking at is you can look at it and say the image is a classic collection of ones and zeros, or the image is the rendering of the image on the screen. The problem we bumped into before is we look at it and say the rendering on the screen is clearly an image. We agree that that's copyrightable, clearly the image. The collection of ones and zeros, we kind of look and say, well, yes, the ones and zeros is also arguably something which is copyrightable.
It's the particular
fixation, pattern, it's a fixation.
We treat it as the same.
But what we've done previously is we've said, but really they're the same thing. They're really the same image. When we get into the AI issue, the answer is actually they're not the same image anymore. We've disconnected them. And when we disconnected them, we now have to decide, is that zeros, ones actually copyrightable? And more importantly, is it the image or not? Because if it's not the image, the answer is it doesn't infringe the image either. But it is the image, but it's not the image. But it is the image.
We framed it this way: is the act of processing or storing a data structure that is itself effectively sufficient to reproduce the expression, is that copying or manipulating the work, the expression, or just the underlying non-copyrightable, non-protected data? Because that's what the AI is doing, and that's the argument that's being made. And the problem is, although it feels like those two things are different, the law is not consistent about this, and this really becomes apparent in music.
Yep, and we're going to move to music. We wanted to do one before, but I think the reason why we want to particularly move to music is we've mentioned it before on the show. We say it repeatedly. Music is weird.
It is unique and weird amongst all the forms of IP, which Kirk and I were just talking about this before we sat down to record. The Copyright Act kind of acknowledges it. When you look at the first right, the right to reproduce the work in copies or phonorecords.
Yeah.
Why do we have to list phonorecords differently? Yeah. Because it's not a copy.
Yeah, and that's the thing is we're like, but a phonorecord's a copy. No, but it's not a copy because it's data. We get into the distinction.
The sheet music is a copy. The phonorecord is not.
But even the sheet music isn't a copy. Let's
talk about that. So going back to my Matrix example, my RGB thing, what if I just give you a number of sound frequencies? I'm going to say 440 hertz, concert A, 440 hertz, and a frequency of 3/4 of a second.
Yep.
Okay. Is that copyrightable? Is it an infringement of anything? No, of course not. Of course, it's just a tone.
Yeah. I can do it with a tuning fork.
What if I give you instructions to emit a combination of those for a certain duration and in a certain order that when you do plays the main theme for Star Wars? Okay.
Yep. That's a literary work. Or sorry, right? Literary musical work.
Yeah, that's. I mean, if I just give you those instructions, plays these three tones for B flat major chord.
Sorry.
I mean, I think we would intuitively say, well, no, that's not an infringement. Or like when your program example, I remember when I was in engineering school, we had to write a calculator program, and we had to write it in, I think, Quick Basic. And I knew how to do music in Quick Basic, but it's very simple. You put the note and the duration. 4 is a quarter note, 2 is a half note, 1 is a whole note. And so when the calculator finished, I programmed it to play the Star Wars theme song in the wrong key, but the key that it was easy to do, which was, I think, C4, G4, F8, E8. Like, am I infringing right now as I give you this code to play the notes? I don't think so, but isn't that what the sheet music does? Just in a more compact, efficient format?
It's just a form of instructions. I mean, and all it is just the instructions of say, take this musical instrument, any musical instrument, and reproduce a sound having this particular wavelength and for this particular length of time. Now, there's some interpretation that goes into there. How fast is adagio? Stuff like that. But you obviously sort of get into, those types of things with it. Well, isn't that exactly what we just did? It's just an instruction sheet. And again, we got to look at it and say, well, there's a copyright in the instruction sheet. I can say the physical writing of sheet music involves an expression of how it's written, by saying the words, by the way I draw the tails on my eighth notes, all that kind of stuff involves particularly expressive work. Is it the musical work? Well, no, not really, but it kind of is, and we kind of put them together. And that's where when we say the things, why do they say to copy or pre-produce in a phonorecord? Well, because a phonorecord's a bunch of bumps.
Yeah.
Well, wait a minute, or magnetic, more modern ones with magnetic pulses. But it's the kind of thing we're going to say, but it's not a copy because it's a bunch of bumps. It's no sound.
It's nothing. Yeah. It doesn't produce anything until you run it through a record player. Another thought I had on that same point. Well, we should talk about the road thing I sent you over our trip. So I bumped into this thing on Reddit where it's a road in, I think, Austria, where they have carved a sequence of grooves into the road, which when your tires go over the grooves, if you've ever come up to like a stop sign in a rural area, they got the rumble strips, and as you slow down, like the tone changes based on the speed of your car. They did this to where if you're going the speed limit, the grooves are spaced and placed in a manner that the road plays Ode to Joy.
Not really. Ode to Joy is no longer under copyright.
Yeah. But, or I guess technically it's Beethoven's, I don't know, the Ninth Symphony.
But Ode to Joy is a movement of Beethoven's Ninth Symphony.
Yeah. So it plays that, so there's no copyright problem. But I texted Kirk and I'm like, don't you need a Harry Fox license for that?
Well, if it was under copyright. But yeah, we got it. And one of the things we got into in a battle between this is, what is it? And part of the thing is Ben was arguing this was a phonorecord.
It's a phonorecord. How is it different from a CD?
I was arguing it's a music box because this is actually the bumps playing the spindles that are bumping against it. Which the question with it is it two different spindles, or, two different tones, or is it moving? Well, the answer to it is one's a phonorecord and one's not under the copyright rules, because mine is not a phonorecord, so it's not called out specifically as being a phonorecord, even though fundamentally they're the same.
Yeah, it was a very strange, weird issue there. So music is peculiar that way, and it's difficult to come up with sort of a principled articulation of why the instructions for how to play the song. Here's another example. I can give you the chords for Hotel California right now. Okay? Yeah. It starts on a B minor, then it goes to F sharp major, and I think A, E, G, D, and then back to E minor maybe, and then back up to F sharp major.
Yeah.
Okay. That just infringes copyright. It's a listing of chords.
Yeah.
And here's the problem. How many songs have the same damn chords?
Well, let's say country
did I infringe
music,
1,000 copyrights just now?
Yeah, country music, 3 chords and the truth. I mean, you don't have that much many options. It's these are really. The other thing I think you get into when you start sort of looking at these things is we've always kind of looked at it and said, yes, there are some copyrights and instructions, but it's very limited. You can't copyright making a recipe. You can copyright the actual writing down of the recipe. So if you physically copy the page of a recipe book, that can be a copyright infringement. But I can make the thing however I want. I can recreate the recipe on my own, because that's making and following the instructions is not infringing the copyright in the instructions.
The Copyright Act is very clear. It says, it's in Section 102, in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, and some other things. Procedure or process. Isn't the sheet music the procedure or process for reproducing the song?
It's the instructions, and you follow the procedure,
Yeah. And in that sense, isn't the JPEG a set of instructions to the computer for how to render the image in a way that a physical painting made of pigment is not?
Yeah. And the problem with it is that's categorically not copyrightable.
But it is.
But it is.
So this is a mess. This is a huge mess. And this tension has been kind of overlaid. Again, the Copyright Act, the current version, was passed in 1976. It was negotiated for decades before that. So all of these rules and principles were put in place before we had personal computers and this widespread infringement. And courts are trying, to their infinite credit, valiantly, to find some way to coherently graft this law under the new reality. But these AI cases are kind of, I think, inextricably exposing, or maybe inevitably is a better word, exposing this inherent tension in a way that doesn't seem to be expressly acknowledged in the cases yet, although it's kind of implicitly present in how the parties are structuring and framing their arguments.
And I really think what we're getting into with it, and it's interesting because we were actually playing around, Ben was trying to play around with ChatGPT beforehand, and one of the things we get into with this is, in some sense, what these cases are really getting into is everybody knows copyright covers expression. What we're bumping into is, what the heck is expression?
Yeah.
And that's the thing where it's like, we've known for years what we meant by expression, and all of a sudden we don't.
I mean, to me, the image example is simple, right? Like, it's not just the expression, it's the original expressive authorship.
Yep.
What did I author in a digital image? It's the image. I didn't write the data. I didn't sit down and go, okay, 1, 0, 0, 0, 1. Okay, I didn't do that. The computer did that for me. So in that sense, I think the law correctly understands that the data is the fixation of the expression, in the same way that I didn't specifically decide exactly where on the page to put every single molecule of ink in a book that I print. I just want the letter R, you know? Yeah. It's the same idea. But this is another problem with copyright, is that ultimately all of this stuff is a gestalt of these little microscopic pieces, and the AI is now pulling it down to that molecular level in a data sense.
Yeah, and that's it was interesting because you commented about it earlier. Why does technology tend to break copyright and less patent? I think part of the reason is, well, but I think part of the reason also for it is that patent has kind of already acknowledged this kind of problem, and the way patents are written and the way patents are granted, they've at least tried to put into place something that says, no, explain what you mean. What level are you talking about? And explain it, which copyright just plain doesn't do. Copyright just kind of assumes it.
And ironically, in patents, what the patent protects is what you've written down in English language in the claims. And that's it. That's what it covers. Copyright's not like that. What does it protect? I mean,
it protects the language, but
it protects I guess the book that you wrote, but not all of it. Yeah. It doesn't protect the narrative structure. It doesn't protect individual words and phrases.
In some sense, you can say it protects the story, but the story exists ephemerally. And the way I kind of put it is, I remember there was a lot of discussion around this when they first had Napster, was the whole discussion where they said the problem that record companies were having originally with Napster and MP3s was record companies sold vinyl. They didn't sell music. They sold vinyl.
Their business model was based on having space on shelves in retail stores where people show up, hand over paper, and get vinyl back.
Yeah, and the key point was making that vinyl reproduce music accurately and well took machines that were outrageously expensive.
Yes.
And we're into our energy barrier problem again.
And then we come along and someone says, okay, well, just do digital. This isn't the digital industry. They don't have any expertise in running servers or managing software or anything like that. That's easy to say. You can't just pivot an entire industry like that. So their fear over this is very understandable.
Yeah, but what you really get into is you get into that question where, again, it came down to what is music? What is recorded music? And the thing I always remember is the whole discussion of whether or not jazz could ever be recorded.
Yeah.
And that was a discussion for a while as to whether or not a recording of jazz is jazz. Because by definition, it must be improvised.
Yeah, jazz is supposed to have an improvisational element to it.
And if it's played, it's not improvised if it's a recording. So
and blues, really, too. Like classic blues music, the solos. You even see that with modern recording artists. Like you go see Metallica or somebody, they'll improvise a solo. They're different every time. Even in songs, I was listening to a recording of Led Zeppelin's Kashmir from the 70s. The version they played at Nebworth was different than the version that's on the album. It's not the same.
Well, I know a lot of it. What I know from country music was Brooks and Dunn, who were very outspoken. The fact that at concerts they would play songs differently to point out that it was live.
Yeah,
that you came to see them live, so therefore we're going to play the songs differently. We're going to do stuff to it, so you know it's live, and you hear something different every time you come to see us, and you get into that idea, and that means that the concert experience is different than the recording experience. We all agree that.
And going back to your patent point, this is another difference that I think is often overlooked. So for a patent, how do I know if I don't infringe the patent? Let's say I have one element of the patent. Let's say it's got 25 things in it. Pick one. I don't have it. Do I infringe?
Nope.
No, of course not. Everybody knows. Everybody agrees. Copyright. Okay, I copy out. I skip one chapter. Do I still infringe?
Is it a transformative fair use?
Right?
We need to do a 4 scale. You get the
All
problem.
you need to know is the answer is neither yes nor no. The answer is I don't know.
The answer is you have to do a 4-part analysis for transformative fair use.
It depends on what state you're in and what you do with it. I mean,
and again, I think this is where what we're really bumping with is and what I kind of wondered about, and I've commented for years. I think copyright has had a poor fit for digital technology for a lot of years, and I have to wonder if AI may break it. Because it may finally hit the point where we really have to analyze what does copyright cover.
Yeah.
And I think even to the question of do we need another form of IP protection which isn't copyright?
We've done it before. We had the vessel hull thing in the 80s, which is like a generis. It's a patent like right, but it's also an industrial design like right.
Yeah.
We've got the Semiconductor Chip Act for mask works. So we've done this before, and so we know we can do it. But it feels like here we have to come up with some sort of coherent doctrinal way to principally separate protectable authorship from underlying data representations of it. Yeah. That is not a trivial or simple undertaking. And this is no insult on the courts. I don't think courts are equipped to do it. I don't think most people are equipped to do it.
I'm not sure anything's equipped to do it because the problem you get into is I think this involves a lot of sitting down and really debating what do we intend copyright to be for.
Yeah, and as data expressions change, a simple example, if I use like a zip to archive something, haven't I made a copy of whatever I've archived, and haven't I made a derivative work?
Well, and the example, this is something that always stuck with me. I remember doing this when I was in computer science, and I'll use this as an example. When I say the idea of saying, what does it mean to copyright something? I remember one day we came in, and the professor had covered the entire of 2 whiteboards in our class with ones and zeros. And it was all ones and zeros. And what he ended up doing was we were talking about data compression. And he went through and he said, well, how can I change? One of the things I can do is I can make these 7 zeros, be it instead of saying 7 zeros in a row, I can make the number 7 followed by 0. Mm-hmm. He went through and he reduced the equations on both whiteboards to 1. In the end, the whiteboard had the number 1 on it. Is the number 1 protected by copyright?
No.
But it was 2 whiteboards worth of ones and zeros when we started. It was just compressed. Well, what does that mean? What is the data behind it? Now, that meant you had to follow a particular compression mechanism. Yep. You had to do the things behind it. But the whole point behind it is we're really up against this question, what is expression?
Yeah.
And that's not a question that we can answer with current law because the current law just says expression is protected. We're now up against the question, what is expression and what part of the expression is protected? And that's what we need to grapple with. And in some sense, that's a philosophical question.
It's a policy choice that Congress is going to have to make. But in the absence of congressional action, courts are going to have to do the best they can.
They have to do it, yeah.
Yeah. So, all right. Well, yeah, it's a wild topic, and as we were talking about this, we just thought that maybe we'd hit on something that's sort of because I think to a lot of people understand that the AI debate feels different, man. It just feels different than stuff we've done before, and people, again, the example of, well, isn't the AI learning just like a human? On a superficial level, yeah, it really feels like it does. But it doesn't, it doesn't work differently. And I think it goes down to this tend to anthropomorphize everything. Going back to where we opened up. Are you training the AI? No, I'm not training anything. I'm having it do a bunch of data analysis and store new data. That's what it's doing. We call that process training because that's how we learn.
Yeah. And at the same time, we're also doing the same thing. Our brain is doing the same thing, but our storage mechanisms are,
opaque.
Are completely opaque. Our algorithms are very different, stuff like that. And that's what we're bumping into is in some sense, we will always have a better understanding of what the LLM is doing than what we are doing. And so we bump into the question of saying, well, then how like it is us? Because, that was kind of a misphrased sentence, but I think it actually came out right.
Oh, it did.
As we just don't know whether or not their algorithm is like us or not. We can look at the black box and say the output looks similar. We know how the input went in, but we look at it and say, but is it the input? And again, that's where we look at it and say, yes, we train by reading lots of books, but don't we train by reading lots of books by understanding the stories? What we're really training on is how to write a story, not how to write a book.
I'm not learning how to write a book by studying how often certain words and phrases appear in that genre and then producing an output based on those probabilities.
In some sense, we're conflating, composition class with linguistics.
Yes, that's a good way to look at it. Or statistics.
Composition is how to write a novel. Linguistics is how to write lots of words that become a novel. They're very different sort of in the way that they look at it. What we really have is AI kind of behaving like a linguist, but generating novels as a linguist. Whereas we have humans arguably generating novels based upon however it is we generate novels, but we don't think it's a linguist.
No, absolutely. All right. Well, we will probably return to this topic. There will be a lot more cases, and there's just so much interesting stuff to unpack here. So we are back. We've been on vacation for the last couple of weeks.
Both of us went on vacation here, so.
And so we don't have our current plans for the future lined up yet, but we will continue to get these episodes onto YouTube if you want to look at it or listen to it there. And hopefully,
speaking of data about things, when we start doing data about these are the episodes on something, is that protectable?
That's a good question.
I had to mention that.
Question for another day, and that's all for this time. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.